Allison Harmon, David Paul Judah versus Reagan Dawn Brown and others. Do I have someone here on behalf of the plaintiffs, Harmon and Judah?
Yes, this is Allison Harmon.
Good morning, Ms. Harmon.
Hi, this is David Paul Judah.
Thank you both for being here.
Thank
Do
you.
we have anyone on behalf of Reagan Dawn Brown? No. And we still not had anyone. If you're here on the phone, you'll have to unmute or disconnect and redo it. All right. Mr. Harmon, I'm sorry, Ms. Harmon, Mr. Judah, who would like to take the lead and give me the information on the case?
I can do that.
Right. What's the reason you're seeking the eviction today? What's the breach?
Non-payment of rent.
Non-payment. And is there a written lease?
There is not.
Okay. Had there been an oral agreement for for the defendant to pay rent?
Yes, ma'am.
How much was the defendant supposed to pay?
$350 per month.
And had the defendant previously paid $350 per month?
No.
They moved in and never paid at all?
Nope. Never paid at all.
Correct.
How long or what months are you seeking unpaid rent for?
July 1st, 2024 through current. But I think when we submitted this, we put it July 1st through August 15th, 2025, thinking she would maybe leave.
Ms. Harmon,
so that was,
Ms. Harmon,
yes,
has this person been unpaid in rent since last year?
Yes,
yes,
ma'am.
Do you have anything in writing where she says, I'm going to pay you, or I know I owe you the rent?
So this is a little confusing because she is a family friend. We did give her a written lease that we never received back to scan in with that amount of payment of rent.
Ms. Harmon,
Yes. Yes, ma'am.
you wrote up a lease before the defendant moved in.
Yes.
And you gave it to her.
Yes.
She didn't sign it.
Correct.
But she moved in and you gave her the keys.
Correct.
And in that written lease, did it require her to pay $350 a month?
Yes, ma'am.
But she never signed the lease. You gave her the keys. She moved in and she never paid.
Correct.
Until this year, had you in writing told her you owe us money?
All right, guys, this opening moment sets the tone instantly. The courtroom is called to order, and right away you feel the tension as the judge scans the room, waiting for the defendants who never show. The plaintiffs announce themselves clearly, but the silence from the other side creates a sense of unease. It's the kind of beginning where you instantly know something is off. No arguments yet, no drama spoken out loud, but the atmosphere already hints that this case will not unfold smoothly.
Yes, ma'am.
And do you have any of her responses to that?
Via text, her saying that she would pay, that she had paid. She asked for account information for our mortgage company to make payments directly there. Paul Judah, my brother, never received any of those payments. But other than texts, and her phone has changed several times, I don't have anything in writing of her saying
Okay.
that she paid. I mean, she said she paid, but she didn't. So it's frustrating, but she did receive a 30-day notice to vacate on August 15th, which was posted on the door. Inside the door. Yeah.
You gave her 30-day notice to vacate?
Yes.
Buckle up, guys, because this is where the story officially begins to unravel. The plaintiffs step forward, calm but clearly frustrated, revealing that the tenant never paid a single month of rent. No written lease, only an oral understanding, yet the defendant lived there without contributing a dime. The judge listens carefully, peeling back the layers as each detail builds the tension. You can hear the disbelief forming as the timeline stretches back over a year. This isn't just a slip-up, it's a long pattern of unpaid promises.
And after the 30 days passed, did she move out?
No, ma'am.
No, ma'am. She's still occupying the property.
All right. And you did provide us with the military affidavit.
I believe so.
I see that. No, you've sworn to it. I got one from Mr.
Okay.
Judah. So Mr. Judah, you
Okay,
said
thank
that
you.
you've personally known the individual for 20 years. You can confirm they've never served in the military or been on active duty based on your personal knowledge. Okay, that's all we need. We have a sworn statement from one of the plaintiffs that you've done, and the reason you have that belief is based on your 20 years of knowledge. Okay.
Correct.
Let's confirm service to the defendant. And here's that return of service. All right, Deputy Mike Steele with the constable's office did affix and leave a copy of the notice with a white nail there at the address, and that was returned and affixed to us, and that was on behalf of Reagan Dawn Brown for cause 25-1546. All right.
Thank you.
All right, now, Ms. Harmon, Mr. Judah, do you have, in the documents that you send to us, is there anything in there from the defendant admitting that she owes money here recently?
No, nothing written, unfortunately. Yeah.
Okay, so I don't have, and this is where you might want to appeal me, right? I understand this is where people think it's strange, like I can appeal if I win. So today with what you've given me, and I take it as all true, right? There's no one to contradict it, and what you've shown me matches up with what you've said in your petition and in the paperwork you've given me here. I don't have any, legally, I don't see any problem with granting the eviction to you for possession. I have trouble granting any amount for the unpaid rent because there's nothing in writing. There's a long time where I'm not making a defense, but I can hear it just strikes me. I don't know. So for
I
me
understand.
today, I would grant you possession with your cost of court, what it costs you to file and serve the defendant, but I'm not going to award anything for back rent. That does not preclude you from appealing my judgment, or, and you can talk to an attorney about this, if you believe you have financial harm as a result of a breach of contract, the eviction doesn't preclude you from pursuing that. Like, let's say a landlord discovers after the tenant moves out after the eviction that there's a hole in the floor or damage has been done. Does that make sense?
All right, guys, here's where things get even heavier. The plaintiffs describe confusing messages, shifting phone numbers, and claims of payments that never existed. The tenant even asked for mortgage information as if planning to pay directly, but nothing ever came through. Then we reached the 30-day notice to vacate, posted clearly, legally, and unmistakably. Yet the tenant remained in the home, ignoring the deadline entirely. The judge's questions cut deeper, revealing a trail of mixed signals and unkept obligations.
So that's,
Yes.
the eviction is about awarding back possession and potentially unpaid rent, but it does not have to be all at once. So I just want to point that out, that you have options still. Okay.
Understood.
Understood.
All right. Now you need to put an appeal bond down. You told me that the monthly bid had been $350. Is she renting an entire home, or was this like a bedroom within a larger unit?
It is an entire home. She was renting it with another person who went to jail and is now in rehab. So, but her rent alone was the $350 per
Okay.
month. So yes,
I'll use that
that
number.
is
Then
all she's responsible for. Mhm.
and I recognize again the numbers here may not match what y'all are in your calculations, but for today, I'm going to say judgment for the plaintiff with possession. I'm going to award nothing for back rent, only cost of court, but I will use the $350 as the monthly rent, and I will put the appeal bond at $700. So it is a non-payment matter, which means that if a party wanted to appeal, $350 every month has to be paid to the court to perfect the appeal. Or
Now this part is where legal pressure reaches its peak. The judge acknowledges the truth of everything presented but draws a hard legal line. Possession can be granted, but unpaid rent cannot without proper written proof. It's a moment that surprises many people, a reminder that fairness and legality don't always align neatly. She explains appeal rights, breaks down how the courts handle these cases, and assigns a $700 appeal bond. The tone becomes firm, procedural, and decisive as the ruling lands.
to avoid a writ of possession. You can perfect the appeal without that.
Okay.
Call attorneys if you want to. I can't explain all of those things.
Yeah.
Just know that, okay? Judgment
Okay,
for the two of you with possession and your cost of court. Either party can appeal. It'll be $700 on appeal.
Okay.
Okay.
Thank you.
All right. Good luck to you both, Mr. Harmon. I mean, Miss Harmon, Mr. Judah. You're both excused. Thank you.
Thank you.
Thank you. Have a good day.
You as well. I always say have a better day.
Thank you.
Yeah. Well. All right.
And then, Your Honor, just because you're probably looking at the docket, looks a little different. So two of them, 49 and 51, those were both the plaintiff non-suits requested during check-in.
Oh, okay. So it looks like
And that's why we have one matter.
just 1551.
No, so 51,
And 49 got non-suited.
yeah, those both got non-suited.
So the last one is 55.
Correct.
Okay. Thank you, Brochet. Then we're going to be, our next case is going to be cause 25-1555. That's Maricela Rodriguez Barr versus Robbie John Gallagher. Do I have someone here on behalf of the plaintiff, Maricela Barr? Ms. Barr, I can see that you're with us. You'll need to. Oh, there you go.
I think I'm here. Thank you.
Good morning, ma'am. Thank you. And we've not had anyone announce on behalf of the defendant, Robbie Gallagher. I will say.
Here we shift into a brand new case, and the tension restarts from zero. Another landlord, another tenant, and another situation where promises to vacate were broken. The tenant said they'd be out by September 30th, but months have passed and they're still there with several rents unpaid. This time there is a written lease, and that changes everything. The judge demands a military affidavit, warns that without it the entire case collapses, and fields a complicated question about multiple defendants. Every second here feels procedural but high stakes.
And one final time, and I will send the request again. If you are here and you called in on the phone ending 452, you're going to need to unmute and announce present. If you have not done so by the end of this case, we will end up exiting. All right then, Ms. Rodriguez. I'm sorry. It is Ms. Rodriguez Barr. Ms. Rodriguez Barr, why don't you tell me why is this eviction being sought against the defendant, Robbie Gallagher?
They gave us notice on August 17th that they would be out on September 30th. They didn't leave on September 30th. They didn't leave on October 31st, and they're still there.
And they have not paid.
And they have not paid.
Okay, let me ask you some questions then. Ms. Barr, do you have a written lease with the defendant?
Yes, ma'am.
Under the written lease, is the defendant required to pay rent?
Yes.
How much rent?
$1,800 a month.
Is there any direct subsidy to you from the government for that rent?
No, ma'am.
Okay. What months? Are there any months of rent that remain unpaid?
They did not pay for June of 23. They did not pay for September or October or November.
Okay, when you said June of 23, do you mean 2023?
Yes, ma'am.
All right, guys, the final part wraps everything with a firm conclusion. The judge calculates unpaid rent down to the dollar, delivering a clear judgment in favor of the plaintiff. She sets a steep appeal bond, reminds them that missing the military affidavit resets everything, and underscores how precise the legal process must be. There's no drama from the parties, only the weight of consequences settling in. The court session ends with a mix of relief, tension, and a reminder that these decisions shape people's lives long after the hearing closes.
Okay, that's too far back. We're not going to deal with that one. But how about September of this year? September and October, November remain unpaid?
Correct. Yes, ma'am. Mm-hmm. Okay. So we're not allowed to receive that for, is there a statute of limitations?
No, but I'm not, for eviction, it's about possession, so I'm going to go with it. You can certainly pursue them in small claims.
Okay, all right. Just trying to, just trying to understand.
It's 2 years back.
Yeah, and we were doing
we were just doing because they haven't paid September, October, and November. So that's the one that we're gonna.
We were just doing a full accounting.
Was this a CARES property?
A what?
A CARES property?
I'm not sure I know what that means. No, I think. What does that mean?
I hear someone in the background. Who is that?
Yes, my coworker, Kathy Nomady.
All right. Do you have knowledge? Was this a CARES Act property?
It's not a CARES property.
No, ma'am.
Okay. What day did you provide the notice to vacate?
October 3rd.
October 3rd.
And how was that delivered to the defendant?
Delivered by hand.
By hand.
And delivery. All right.
And posted on the door.
To your knowledge, or have you provided us with a copy of the military affidavit, a sworn
Yes.
statement of their military service?
Oh, military, they are not in the military. It is on the lease that they said they are not.
We still need to get a sworn statement from you, Ms. Barr. So in order for the eviction to become final today, you need to submit to us in writing a sworn statement why you believe that and what it's from, right? So I think I heard in the background, if you believe it's because of what you've got at information of a lease, but you have to give us a sworn statement about their military status or the eviction can't be finalized.
And so how should we submit that?
You can email it to us.
Email
Email?
Mhm.
We'll do that today.
All right. We can give you 24 hours to submit that. If we don't receive it though, Ms. Barr, the judgment is going to actually be for the defendant because you won't have given me a necessary document.
We'll do it today.
Fantastic.
Do we have that email address?
Yes, it's in all the documents that we gave you, and you can always call our main line and get it, but it's jp3civil@traviscountytx.gov.
I'm gonna
And
put it in the
any-
chat too.
Oh, fantastic. Rashay, we're going to put in the chat box for you too, Ms. Barr. Also, when you email us in the in the reason you're emailing, like the 4-line or not the
subject.
Subject?
put the cause number, put military affidavit for 25-00155
Okay.
for today. And that way, when we see it, we'll flag it and go, okay, that's the thing, because we're going to be looking for it to process. All right. And let me just see the return of service. So we did get back a return of service to the defendant. I'm going to highlight that now. That defendant Gallagher did receive notice. Robbie John Gallagher did receive notice in person directly to them from Deputy Gamboa, who works for the constable's office. Oh, pardon me. Okay, so service has been effected. And
May I ask a question?
certainly.
In the lease,
There are 3.
there's 3 people on the lease. And so we went ahead and filed this one for Robbie John Gallagher. We also filed another one where we're scheduled to be heard on Thursday for Alice Ojeda, I'm sorry. So my question is, should we even go through that process or just this will be enough?
Ms. Barr, I can't answer that. That's legal advice. I would say contact an attorney or contact someone who advises landlords about what is the best situation for you, given that you have more than one tenant and more than one defendant and you have more than one case.
Okay.
Okay.
Okay. So,
I can't inform you.
but we're
Ms. Barr,
scheduled. Yes,
I'm
ma'am.
going to give you information. The only thing that your lawsuit is active against is its named defendants. So if you have another person, this judgment is only good as to Mr. Gallagher.
Okay, so we'll show up on Thursday. That was my question.
Whether you should or should not is totally up to you, right? I'm just saying that this judgment is only naming Robbie John Gallagher, and therefore it is only effective or useful as to that defendant, Robbie John Gallagher. Okay.
And that helps me make my decision. Thank you.
Okay. All right. Today it's going to be, I did receive back the return. Deputy Gamboa did see that. We saw that. Okay. Today it's going to be a judgment for the plaintiff. It's a non-payment matter. I do find monthly rent of $1,800 for September and October, and then a prorated amount for November. I calculated $4,680. So that would be the judgment for the plaintiff along with your cost of court. Either party can appeal. To appeal, I would double the monthly rent and put the appeal bond at $3,600. And Ms. Barr, very importantly, if you do not submit the military affidavit, the judgment becomes moot and you would have to start the process over.
Yes, ma'am. We'll do it right now.
All right, fantastic. Then any other questions?
No, why were we last?
Check in and the number of the case. So you were one of the last cases filed before we set the docket. It doesn't matter. But thank you,
ma'am. You have a nice day.
Thank you. All parties are.
I was going to say, Ms. Barr, there is a resource in the chat also in regards to that military affidavit that
Yes,
can be
ma'am.
located on our website.
How do I get to the, oh, I see it. Okay.
And it's that bottom one. Thank you, Brashay. I see she's directly linked you to what helpful links for how to get information regarding the military affidavit.
Okay. Well, okay. Thank you so much.
All right, thank you.
Y'all have a nice
Parties are
day.
excused. Thank you. And Brochet, outstanding as always. We have
Thank
not
you.
had anyone from this phone ever identify themselves or disconnect or do anything. So we are going to be ending the court session and that person will be removed. If you can hear me and you're on that phone ending 452, please contact the main line for the courthouse and we will try to assist you as best as we are possible at that point. All right. Thank you. All parties are excused.